One mistake on your background check in 2026 could cost you $250,000 in fines and up to 10 years in federal prison. If you're planning to buy any firearm in the next 18 months, what I'm about to tell you could mean the difference between walking out with your purchase or facing a federal felony charge. I'm breaking down 7 critical background check changes coming in 2026 that could delay, deny, or even criminally flag law-abiding gun buyers who've passed every check before. By the end of this video, you'll know exactly what's changing, which old records will suddenly matter, and the one action you must take right now to avoid getting caught in the system. Here's why this matters. The FBI just announced they're linking databases from 47 states that were never connected before. That bar fight from 1998, that dismissed protective order, that mental health record you thought was sealed, they're all about to surface, and you need to know about it before you sign another Form 4473. Point 1. More criminal records will suddenly exist in the system. Starting January 2026, the FBI is requiring all 50 states to upload every criminal record, including dismissed, reduced, and expunged cases, into NICS. Right now, only 31 states report consistently. That's about to change, and here's the problem. You're standing at the gun counter. You've bought firearms for 20 years with zero issues. You fill out the 4473, the dealer runs your name through NICS, and suddenly you see "denied" flash on the screen. You're confused. You haven't done anything wrong. You haven't even gotten a speeding ticket in a decade. What happened? That misdemeanor from 2003 that was pled down to disorderly conduct and eventually dismissed? Your state never reported it to the federal system. Under the 2026 mandate, they just uploaded 500,000 old records, and yours was in that batch. The way it's coded in the database, assault-related offense, triggers an automatic flag, even though the actual outcome was a dismissal. Here's the consequence. You're now facing a federal denial. To get it overturned, you'll need to file a NICS appeal, gather court documents proving the dismissal, potentially hire an attorney, and wait anywhere from 90 days to 6 months for resolution. During that time, you can't buy any firearms. If you attempted to buy anyway by lying on another 4473, that's a federal crime, up to 10 years in prison and a $250,000 fine under 18 U.S.C. Section 922(a)(6). Here's what you do right now. Request your criminal history from your state's repository before the end of 2025. In most states, you can get this online for $20 to $50. Look for anything: arrests, charges, dismissed cases, expunged records that might be lurking. If you find something confusing, get copies of the final disposition showing how it was resolved. If it was dismissed, make sure the paperwork clearly states dismissed or null proska. Keep those documents in a safe place, because you may need them at the gun counter in 2026. If you've ever been arrested for anything, even if charges were dropped, you need to verify that the final outcome is correctly recorded. That's your insurance policy against a wrongful denial. But there's something even more dangerous coming with domestic violence records. Point 2. Domestic violence and protective order checks are getting brutal. The 2022 Bipartisan Safer Communities Act added new reporting requirements for domestic violence protective orders. Starting in 2026, those requirements kick into full enforcement, and the FBI estimates this will add 180,000 protective orders to NICS that aren't currently in the system. Picture this. You went through a divorce in 2015. It was messy. Your ex filed for a temporary protective order during the proceedings. The judge held a hearing 2 weeks later, found no grounds for a permanent order, and dismissed it. You moved on. You've bought guns since then with no problems. Under the 2026 rules, that temporary order, even though it was dismissed, gets uploaded to the federal database. The system sees protective order and domestic relationship and flags your name. When you go to buy your next firearm, you get hit with delayed. The dealer tells you to come back in 3 business days. Here's where it gets worse. Under federal law, 18 U.S.C. Section 922(g)(8), you're prohibited from possessing firearms if you're subject to a qualifying protective order. The key word is qualifying. It has to meet specific requirements. But the NICS system doesn't always distinguish between a temporary emergency order that was dismissed and a permanent restraining order that's still active. The computer just sees order and domestic. The consequence: you could be wrongfully denied. To fix it, you'll need to provide documentation proving the the order was dismissed or didn't meet the federal definition of a disqualifying order. That means tracking down court records from a decade ago, possibly hiring a lawyer, and filing a formal NICS appeal. Cost: easily $2,000 to $5,000 in legal fees. Timeline: 3 to 6 months, minimum. Here's your solution. If you've ever been involved in any domestic case, divorce, child custody, protective order hearings, anything, get copies of all final orders and dismissals right now. Call the courthouse in the county where it happened. Request certified copies of any protective order petitions and their outcomes. Make sure the paperwork clearly shows: 1. The order was temporary. 2. It was dismissed or not renewed. Or 3. It didn't include the specific prohibitions that make it federally disqualifying. Document everything. If you're not sure whether an old order qualifies as a federal prohibition, consult with a firearms attorney in your state before 2026. Don't guess. Don't hope. Know for certain. This next change is catching people who moved across state lines. Point 3. Interstate database linking will catch people who moved states. Right now, if you were arrested in California in 2008, moved to Texas in 2010, and started buying guns in Texas, there's a decent chance that a California arrest never followed you. States don't always share data efficiently across borders. That's about to end. The FBI is rolling out the Interstate Data Exchange, or IDX, which automatically cross-references your name, date of birth, and social security number across all 50 states. Every arrest, every charge, every protective order, every mental health adjudication, all of it gets linked to your federal record instantly. You're at the gun store in Texas. You moved there 15 years ago. You've bought guns in Texas with 0 issues. You fill out the 4473, and for the first time ever, you see delayed. You ask the dealer what's going on. He doesn't know. You wait. 3 days later, you get a letter, denied. Turns out that DUI arrest in California in 2008 was initially charged as a felony because there was property damage. You pled it down to a misdemeanor, did your probation, and moved on. But the original felony charge is what California uploaded to the new system. The FBI sees felony arrest and guilty plea in their database and assumes you're prohibited. The consequence: you're denied. To fix it, you need to track down court records from California showing the plea agreement, the final conviction level, misdemeanor, not felony, and proof that you completed all terms. If you don't have those records, you'll have to contact the California court from Texas, request certified copies, and submit them through the NICS appeals process. This can take months. Some people give up. Others spend thousands on attorneys. Here's what you do. If you've lived in multiple states and had any legal issues in any of those states, request your criminal history from each state you've lived in. Yes, every single one. Most states let you request this online. Check for anything that might be coded incorrectly or look worse on paper than it actually was. If you changed your name, marriage, divorce, legal name change, make sure you have documentation showing the name change so you can prove all these records belong to you and were properly resolved. Bring copies of everything to the gun store if you're even slightly concerned about a past issue. The system doesn't care that you moved on. It cares what the database says. You need to control your own narrative before NICS does it for you. But wait, there's an even more confusing category coming that's catching people off guard. Point 4. Mental health records are being reported in ways that hurt voluntary treatment. Federal law prohibits gun ownership if you've been adjudicated as a mentally defective or committed to a mental institution under 18 U.S.C. Section 922G(4). The key word is adjudicated. That means a judge or legal authority made a formal determination that you're a danger to yourself or others, or you lack the mental capacity to manage your own affairs. Here's the problem. Not all states understand that distinction. Some states are uploading voluntary mental health admissions, crisis interventions, and even temporary psychiatric holds that don't meet the federal standard for prohibition. They're doing this because they're afraid of liability, and they'd rather over-report than miss someone. You're dealing with depression in 2012. You voluntarily check yourself into a hospital for 3 days to stabilize on medication. You're never adjudicated by a court. You're never involuntarily committed. You cooperate fully, get the help you need, and move forward with your life. You've passed background checks since then without issue. In 2026, your state uploads that voluntary admission to NICS as part of their mental health reporting compliance. The system sees psychiatric admission and mental health treatment, and it flags your name. You go to buy a firearm, and you're denied. The consequence: you're prohibited from buying guns, even though federal law doesn't actually prohibit you. Now you're stuck in a nightmare. You have to file a NICS appeal, provide medical records proving it was voluntary, possibly get a lawyer involved to to argue the federal standard and potentially wait a year or more for resolution. Some people never get it fixed. They just give up on owning firearms. Here's your solution. If you've ever received any mental health treatment, voluntary admission, emergency hold, court-ordered evaluation, anything, you need to determine right now whether it meets the federal definition of a disqualifying adjudication. Get copies of all records. If it was voluntary, make sure the records clearly state voluntary and no court order. If there was a temporary emergency hold, get documentation showing it was released and not converted into an involuntary commitment. If you're not sure, talk to a firearms attorney who understands mental health prohibitions. Do this before you fill out another 4473. If you lie on the form and say no to the mental health question when the answer should be yes, or when it's unclear, that's perjury. Up to 5 years in prison under 18 U.S.C. Section 1001. If you answer honestly but the record is wrong, you'll be denied and you'll have to appeal. Either way, know where you stand now. This next issue is something almost no one is paying attention to, but it could destroy you. Point 5. Edge cases are no longer slipping through automatically. For years, the NICS system has had gaps. Certain misdemeanors, certain drug charges, certain quasi-criminal cases, they'd slip through because they didn't perfectly fit into a clear prohibition category, or because the reporting was inconsistent. In 2026, those gaps are closing fast. The FBI is implementing automated review protocols that flag edge cases for human review. That means cases involving misdemeanor crimes of domestic violence, Lautenberg Amendment cases, state marijuana convictions where the person is a medical marijuana card holder, old juvenile cases that may or may not have been sealed properly, misdemeanor assault charges that may or may not involve domestic relationships, cases where charges were reduced from felonies to misdemeanors. You got into a shoving match with your brother-in-law at Thanksgiving in 2010. Police were called. You were charged with misdemeanor assault. It was a family member, domestic relationship under state law, but the charge was pled down to disorderly conduct with no finding of a domestic connection. Case closed. Under the new system, that case gets flagged because it started as a domestic assault. The algorithm says, possible Lautenberg Amendment violation requires human review. Your background check goes from instant to delayed while someone at the FBI reviews the case file. If they decide it qualifies as a misdemeanor crime of domestic violence, you're permanently prohibited from owning firearms under 18 U.S.C. Section 922G(9). The consequence: even if the final plea didn't include a domestic violence finding, the FBI might interpret it differently. You could be denied. You could also face prosecution if you already own guns, because 922G(9) is retroactive. People have been arrested, tried, and convicted for possessing guns after cases from decades earlier were reinterpreted as domestic violence prohibitions. Here's what you do. If you've ever been involved in any altercation with anyone you were related to, lived with, dated, or had a child with, even if the case was dismissed or reduced, get the court records now. Look for any mention of domestic, family, or household member in the original charging documents. If it's there, find out whether the final plea or conviction included a finding of domestic violence. If it didn't, get certified copies proving that. If you're in a state with legal marijuana and you have a medical card, understand this: marijuana use is still federally illegal. Question 11.E on the 4473 asks if you're an unlawful user of controlled substances. If you answer no, and you're using marijuana, medical or not, you're lying on a federal form. That's a felony. If you answer yes, you'll be denied. There's no clean way around this under federal law right now, and the 2026 changes will make enforcement tighter. Talk to a firearms attorney if you're in an edge case. Don't gamble with your freedom. But here's the most dangerous part that almost no one understands. Point 6. Data retention and digital paper trails are permanent now. Every time you fill out a 4473, that form stays with the dealer for 20 years. If the dealer goes out of business, it goes to the ATF. Every time NICS runs your name, that transaction is logged. Starting in 2026, the FBI is expanding data retention policies to keep more detailed records of every background check transaction indefinitely. What does that mean for you? It means mistakes compound, errors replicate, bad data spreads. You fill out a 4,473 in 2015. The dealer accidentally transposes 2 digits in your social security number. It goes into the system wrong. You're approved anyway because the error didn't match anyone else. No harm, no foul. But that incorrect SSN is now in a database somewhere. In 2026, you fill out another 4473. This time, the correct SSN is entered. The system cross-references your name and birth date, finds the old transaction with the wrong SSN, and flags it as a potential identity fraud issue. Suddenly you're delayed, while someone manually verifies you're not trying to evade the system by using multiple social security numbers. The consequence: every small mistake you or a dealer makes on a 4473 can come back to haunt you. If you've filled out a dozen 4473s over the years, and even one of them has bad data, that bad data can trigger a red flag years later when the systems get better at linking records. Here's your solution. Every time you fill out a 4473, double-check everything before you sign. Make sure your full legal name is spelled correctly, including middle name. Your current address is accurate. Your social security number is correct. Your date of birth is right. You're using the same name format every single time. Don't use John A. Smith one time and John Andrew Smith the next. If you've ever used a different name, maiden name, nickname, legal name change, make sure you have documentation ready in case the system flags you for having multiple identities. Also, if you've been denied in the past and you successfully appealed it, keep copies of the appeal resolution. Once your appeal is granted, that information should be in the system. But if it's not, and the old denial is still there, you could be denied again for the same issue you already fixed. The system is not smart enough to forget its mistakes. You have to actively manage your own record. This last one is where I see the most panic and the most arrests happening. Point 7. Lying on the 4473 is a federal felony, and they're prosecuting more aggressively. Question time. Have you ever filled out a 4473 and thought, I'm not sure if I should answer yes or no to this question, but I'll just say no and hope for the best? If you have, you need to understand something. Lying on ATF Form 4473 is a federal felony under 18 U.S.C. Section 922A(6). The penalty is up to 10 years in prison and a $250,000 fine. And starting in 2026, the ATF is dedicating more resources to prosecuting 4,473 violations, especially for people who lied and were later caught. Here's how it happens. You fill out a 4,473 in 2024. You answer no to the question about prior felony convictions because you convinced yourself your old felony was expunged and doesn't count. The dealer runs the check. NICS doesn't flag it at the time because your state hasn't reported the record yet. You're approved. You buy the gun. You go home. In 2026, your state uploads that old felony conviction to NICS. The FBI runs an audit comparing old 4,473s to newly uploaded records. They see that you bought a gun in 2024 and you're a prohibited person. Now you've got two problems. 1. Illegal possession of a firearm as a felon, and 2. Lying on a federal form. The consequence: ATF agents show up at your door with a warrant. They seize your firearms. You're arrested. You're charged with illegal possession, 18 U.S.C. Section 922(g)(1), and false statements, 18 U.S.C. Section 922(a)(6). That's 2 federal felonies. You're looking at a mandatory minimum sentence if you go to trial and lose. Even if you take a plea deal, you're a convicted felon twice over, and you'll never legally own a firearm again. This isn't theoretical. The ATF prosecuted over 200 cases of 4,473 violations last year. That number is expected to triple in 2026 as more records surface and more discrepancies are caught. Here's the solution. If you're not 100% certain how to answer any question on the 4473, do not guess. Do not hope. Do not round it off. Stop. Leave the gun store. Talk to a firearms attorney before you fill out the form. Common situations where people lie without realizing it. Saying no to felony convictions when they had a felony that was later reduced to a misdemeanor. The original charge still matters in some cases. Saying no to domestic violence when they pled guilty to a misdemeanor assault involving a family member. Saying no to drug use when they're actively using marijuana, even with a state medical card. Saying no to mental health adjudications when they had a court-ordered evaluation years ago. Saying no to restraining orders when they were subject to a protective order that's still technically active. If any of this applies to you, get legal advice first. The cost of a 1-hour consultation with a firearms attorney is $300 to $500. The cost of a federal prosecution is your freedom, your gun rights, and potentially a decade of your life. Do not lie on the 4473, ever, for any reason. It's not worth it. Let's recap the 7 changes coming in 2026 that could destroy unprepared gun buyers. More criminal records will suddenly exist. Old arrests and dismissed cases will surface and cause denials. Domestic violence checks are getting brutal. Temporary orders from years ago can disqualify you. Interstate database linking will catch people who moved. Your past will follow you everywhere. Mental health records are being reported incorrectly. Voluntary treatment is being confused with adjudications. Edge cases are no longer slipping through. Gray areas are now flagged for human review. Data retention is permanent. Every mistake on every 4473 you've ever filled out can come back to haunt you. Lying on the 4473 will get you prosecuted. The ATF is cracking down hard on false statements. Any one of these changes could cost you thousands in legal fees, months of appeals, or even federal felony charges and prison time. Here's what you need to do before these changes hit. Request your criminal history from every state you've ever lived in. Get copies of all court documents for any past arrests, charges, or cases. Verify that dismissed cases are properly recorded as dismissed. Document any protective orders and their final outcomes. Confirm whether old mental health incidents meet the federal standard for prohibition. Make sure your identification and personal information is consistent across all records. Never, ever lie on a 4473. If you're unsure, talk to a lawyer first. Don't let confusion about the 2026 background check changes cost you your gun rights or your freedom. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex federal gun laws every week so you can buy and carry with confidence. Next video, I'm covering the concealed carry law changes coming in 2026 that could get you arrested even if you have a valid permit. You won't want to miss it.